say right off the bat, it's wonderful to see so many Michiganders present, including friends and family members of the team. I think that's great that there's so many people that support the team. We're going to introduce ourselves, and then after you introduce yourselves, we're going to ask you about question one. My name is Dan Salzman. I'm a judge on the Colorado Court of Appeals in Denver, Colorado.
I am Gus Chin. I'm a municipal judge for Utah.
My name is Dr. Michael Anderson. I'm the Vice President for Academic and Student Affairs at Bemidji State University in northern Minnesota.
Thank you for allowing us to testify before you today. We are a unit composed of 3 juniors from East Grand Rapids High School representing the great state of Michigan. My name is Catherine Donnelly, and when I'm not studying the Constitution, I'm participating as a delegate at Model United Nations.
My name is Alex Adams, and when I'm not reading Federalist Papers, I'm jumping for varsity pole vault.
My name is Emily Johnson, and when I'm not reading SCOTUS blog, I'm tutoring underclassmen. And our wonderful coaches are Mr. Alex Constantelos and Mr. Adam Horos, and we are Unit 3.
Well, good. I'm glad to hear that you're not spending 24 hours a day working on We the People.
And we'll count against you, though.
Let me read the question. As I said, it's question 1. In a letter to Abigail Adams, Thomas Jefferson wrote that the Constitution meant that its coordinate branches should be checks on each other. But the opinion which gives to the judges the right to decide what laws are constitutional and what not only for themselves in their own sphere of action, but for the legislature and executive also in their spheres, would make the judiciary a despotic branch. Do you agree or disagree with Thomas Jefferson's opinion about judicial review? Why? What limits, if any, should be placed upon the Supreme Court's power of judicial review? Explain your position. To what extent, if any, does the power of judicial review exist in other democracies? What useful lessons, if any, can be learned by understanding how judicial review is practiced in other nations? Explain your position. You may begin.
In the teeth of Southern intransigence, the Supreme Court demanded that Arkansas adhere to the decision in Brown v. Board of Education, affirming the federal judiciary as supreme in the exposition of the law. Cooper v. Arkansas, a unanimous court, professed that respect for its rulings is an indispensable feature of our constitutional system. The Supreme Court declares itself final arbiter of the law. But is judicial supremacy consistent with the Constitution?
The essence of Article 3 judicial power is to declare what the law is. Chief Justice Marshall observed, if 2 laws conflict with each other, the courts must decide on the operation of each and resolve the clashes in favor of the Constitution. Furthermore, we concur with Alexander Hamilton's assertion in Federalist 78 that this does not suppose the superiority of the judicial to the legislative power, only that the power of the people is superior to both.
Nevertheless, there has been resistance from the beginning. Thomas Jefferson feared a despotic judiciary and preferred to place the power of review in the state legislatures under the 10th Amendment. Other presidents, such as Lincoln and Roosevelt, have advocated for departmentalism, the idea that each of the 3 branches is co-equal in interpreting the Constitution.
We disagree. Despotism is not to be feared, for when the court flies too close to the sun, it gets burned. From President Lincoln's open defiance of Dred Scott to FDR's threat to pack the court, backlash by the other branches ensures that Jefferson's concerns do not hold up. Later, activism by the Warren Court brought greater scrutiny to the nomination process, ensuring future courts would have fewer fire breathers like Justice Douglas and more self-proclaimed judicial minimalists like Chief Justice Roberts.
Legislation provides a further check by which rulings may be thwarted or subverted. Kentucky only has 1 abortion clinic, despite Roe v. Wade. We recognize the importance of these external limits and others such as the exceptions clause and impeachment process, yet the most essential checks on the courts are self-imposed. The least dangerous branch, unable to enforce its ruling, usually exercises its power cautiously.
These self-imposed limits include stare decisis, or refusal to issue advisory opinions in the political questions doctrine, as affirmed in Nixon v. U.S. In addition, the court is limited to justiciable Article 3 cases or controversies. The court delayed action on same-sex marriage in Hollingsworth v. Perry by finding that an activist group did not have standing to sue. We believe these informal checks are sufficient. Any additional constraints and the judiciary would be powerless.
International examples show that healthy democracy can still exist with other forms of judicial review, or none at all. Britain's system of parliamentary sovereignty, for example, excludes judicial oversight. Indeed, the judges of the High Court were attacked in the press as enemies of the people when they ruled that the recent referendum was not sufficient to trigger withdrawal from the EU.
In his Virginia plan, Madison proposed a council revision that inserted a judicial check directly into the lawmaking process. It is fascinating, then, to see how many nations with dedicated constitutional courts have implemented Madison's vision. Germany gives a separate court jurisdiction to examine the constitutionality of all legislation, thus bypassing justiciability requirements via Article 3. Our courts were unable to weigh in on crucial sections of the Patriot Act for over a decade, a problem the German system would not encounter.
But our judiciary has produced victories of its own, as judicial review has become an indispensable check. According to journalist Linda Greenhouse, such rulings as those on Trump's executive order by an independent judiciary make us look strong. They are the envy of the world, unthinkable in most parts of it. The branch Jefferson feared as an oppressor has again and again led the charge in the cause of liberty. Thank you. We are now ready for your questions.
Thank you for your opening statement. Let me start by asking you, in addition to United States v. Nixon, which you mentioned, to what extent does judicial review extend to review of decisions of the executive branch?
Judicial review has definitely extended to reviewing the executive branch's actions, and in fact is the most crucial check and one of the only checks that the Supreme Court can exercise. And that can be seen in Korematsu v. U.S., where the Supreme Court upheld Executive Order 9066 that called for the internment of Japanese Americans.
And we see in recent current events that there has been a big conversation between the judiciary and President Trump in regards to his most recent executive order. And although the Hawaii District Court recently struck down his executive order, because the court has neither the power of the purse nor the sword, we are unsure if President Trump will actually enforce this decision.
And we see this check also used in Goldwater v. Carter, where President Carter tried to end the treaty with Taiwan, and the court tried to weigh in on this decision, but it was rejected because it was a political question.
There's a lot of talk about in history whether a court decision is an activist one. Let's take Roe v. Wade and Citizens United. Which of these cases, if either is, an activist decision?
Roe v. Wade is definitely an activist decision because this decision created an unenumerated right and essentially inscribed a policy into our law with the creation of first trimester abortions that should have been created by the legislative body, which is most responsive to the people, and I believe that the Supreme Court should not be making such activist decisions.
Citizens United was also an extremely activist decision, though. And I believe that the Supreme Court was right in making this decision because the legislative branch was not being active in doing so. And I think the Supreme Court is extremely helpful in times of our democracy that we have in our country, because when the legislative branch is not acting, sometimes it is up to the judiciary to make these policy changes.
So it's okay with you, or your team, I should say, that a corporation has the same citizen status as a person?
I do think that it is okay for the corporation to have the same citizen status as because I believe that it's the First Amendment right, and therefore campaign finance should be protected under the First Amendment.
And money equals speech.
Yeah, as Buckley v. Valero.
Given your position where there's an absence of enumerated rights, do you think that the court should not review matters that are not considered to be part of what the framers thought of, given our modern day lifestyles, etc.?
I think that different justices on the Supreme Court have used different philosophies in interpreting the Constitution, and one of these theories that does believe that unenumerated rights should be included is the living document theory, in which Justice Stephen Breyer is a major supporter of in cases such as Obergefell v. Hodges, which ruled that the right to same-sex marriage is incorporated under the liberty aspect of substantive due process.
But if you look at Roe v. Wade, would the framers have anticipated that a woman's right would be in any way be threatened by virtue of a legislative act? Could they have anticipated that?
I don't think that the framers could have anticipated this. And I think with the use of substantive due process, our court has continued to evolve. However, I also think it's important for our court to evolve with the evolution of our own society. So, although I don't think the framers necessarily anticipated the court making this type of decision, or this even being an issue, I think it's important that they do continue to decide on these issues.
Thank you.
In First Amendment cases, the Supreme Court has written many opinions using time, place, and manner regulations, but those standards are not mentioned anywhere in the Constitution. Do you think it's appropriate that the Supreme Court has come up with those three factors to decide First Amendment cases, or is that an overreaching on the part of the Supreme Court justices?
I think that it is an expansion of the Supreme Court's rights in regarding the time, place, and manner of such First Amendment issues. However, the Supreme Court has weighed in on things and cases such as this in the Socialist Party v. Skokie case, in which the Supreme Court did protect the rights of the Socialist Party in regards to the march that they wanted to conduct, although this is a very minority group.
Do you think the court's inability to enforce its own decisions render it weak?
I wouldn't say that it renders the court weak. However, I do think that it acts as a check, an appropriate check against the court. But it definitely is more beneficial for the court when the other branches of government are in accordance with its decisions. And we can see this with the Brown v. Board of Education case, in which the executive branch was in agreement with the decision and sent the 101st Airborne to protect the Little Rock 9.
Were there other factors that influenced that agreement with the court? With the court's decision, were there other factors that influenced the executive branch's decision to uphold or to support the decision that you can think of?
I think
We'll hold that thought for a future.
And let's show our appreciation for the team.
Sure. Good job pushing back on activist court decisions. You know, I think the whole point is in our society is that we have to learn how to disagree without beating each other up. But I disagree on Citizens United. I'm not sure I can see corporations as citizens. I'm not sure our framers could either. But that's the whole idea, isn't it? That we can be on other sides of issues. I really like the fact that you went down this list of informal restraints against the court, from stare decisis to precedent to the political issues doctrine. That was really a thoughtful way to approach. And the notion that when the court flies too close to the sun, it gets burned. It set me thinking, now, what cases would I say? So that, when you make an old man think, that's good. But the whole notion of the absence of enumerated rights was a skillful tactic back in your response. Good work.
Thank you. I agree with my colleague. I do like your approach. I particularly appreciate your responsiveness to the questions that were thrown at you, which you could not have anticipated, even though there were maybe disagreements. You addressed them thoughtfully, so I do expect that. And I like the statements that you have made in terms of judicial review being an indispensable check, and the different approaches you took in addressing the principal questions. So thank you.
I liked a lot of different aspects of your presentation, starting with citing Cooper v. Aaron at the very beginning of your opening statement. I think that's one of the most important cases dealing with judicial review. And as you may know, that case was signed separately by all of the Supreme Court justices because they thought it was such an important decision on the power of judicial review in the face of disobedience by Little Rock school officials in implementing Brown versus the Board of Education. I like that you used the example of President Lincoln in defiance of Dred Scott, but you might have mentioned that before he was assassinated, he also supported the adoption of the 13th Amendment, which I think is significant.